Good evening, Chief Justice.
How are you this evening?
Hey, I'm shivering, Chief Justice. But I hope I'll cope.
No, you will cope.
Thank you very much, Chief Justice.
You'll cope. Before I proceed, I need to make a declaration in regard to this candidate. We were at high school together many decades ago. He was, I can't remember whether 1 or 2 classes ahead of me. Was it 1 or 2 classes ahead of me?
2, Chief Justice.
2, yeah.
Yes.
In 1976, and I think we were in the same high school for, was it 2 years before you left, or did you go up to matric at seminary?
I went up to matric, Chief Justice, yes.
Oh, so we would have been together in the same school for 3 years. Because when you were in matric, I would have been doing what was called Form 3.
That's right, Chief Justice.
Yeah. And I think he recruited me to an internal football club. And maybe some of you won't believe this, but I was a very good striker.
Yes. I even remember, Chief Justice. I even remember.
I played number 9.
Yeah.
Well, are you confirming what I'm saying?
I am, Chief Justice.
You see, there is a witness who is corroborating.
We need proof, Chief Justice. We need proof.
We do.
We need proof.
He too was a very good soccer player. He was a great dribbler. So I wanted to declare that we know each other. But over the past whatever years, is it about 50 years now if you count from those years? Over the years, I think I've seen him very infrequently.
Yes.
I don't think over the past 40 years I've seen him more than twice or thrice, but occasionally we have been in touch. So I just thought I would disclose that, but also just take this opportunity to make sure that there is a witness who can corroborate that I was a striker. Okay, all right. Thank you very much. Mr. Phoswa, I'm going to ask you questions. And after I'm done, I will ask the acting judge president to ask you questions. Thereafter, you will be asked questions by the MEC who is representing the Premier. And thereafter, it will be those commissioners who might have questions for you.
I understand, Chief Justice.
Yes. I see that in terms of qualifications, you have a Diploma Juris, a B Juris, an LLB, and an LLM. You obtained the Diploma Juris and B Juris, I think, from the University of Zululand. The LLB, did you get it at University of Natal, KwaZulu-Natal?
No, also from the University of Zululand.
Of Zululand as well.
That's right.
Is it only the LLM that you got from the University of KwaZulu-Natal?
That is correct, Chief Justice.
Yes. The Diploma Juris, once you obtained your B Juris, did it still stand on its own, or did it not get subsumed by the B Juris?
I think...
If you do a Diploma Juris first and then you do a B Juris, don't you get enough credits so that it's only the B Juris that you hold after that, and the Diploma Juris falls away.
I think it may be like that, Chief Justice. I think it may be like that.
Yes, because the subjects would have been very much the same, except that the ones for the Diploma Juris might have been at a diploma level, and then the B Juris ones would be a little advanced.
That is right, Chief Justice, yes.
Okay, and then you got the Diploma Juris in 1985, and the B Juris in 1987, the LLB in 1996, is that right? Or is that correct?
I think so, yes, Chief Justice.
Yeah.
Yes.
Okay, all right. You started your working career as a clerk in the Department of Finance in the KwaZulu government, and later on you became a clerk in the Department of Justice under the KwaZulu government, and ultimately you became a prosecutor at Pungashe Magistrates Court, and later on you became a magistrate. Was that at Pungashe as well, initially?
In Ikopo, Chief
Or
Justice.
at Ikopo?
Yes, yes.
You became a magistrate there. And I see that you were doing both civil and criminal matters when you were a magistrate.
That is correct, Chief
At
Justice.
Ikopo.
Yes.
And later on, 1999, up to now, you became a regional court magistrate, is that right? Or you say it's presiding officer, I assume. That's what.
In 1999, Chief Justice, I was transferred from Ikopo to Magistrate Camperdown, still as a district court magistrate. And in 2010, I was then appointed a regional court magistrate.
Oh, okay.
Yes, Chief Justice.
Okay, well, here it's written 1 August 1999 to date. Magistrate, Regional Court, Presiding Officer, Criminal and Civil Court. Okay, and then you sat as an assessor in the High Court with Judge Msimang for certain periods in 2008. Is that right?
That is correct, Chief Justice.
Yes, and you have also acted as a judge in the High Court in KZN.
That is correct, Chief Justice.
Yes. Are you able to share with the commissioners about, share the length of the period of your acting stints if you put them together? How many weeks or how many months they were? Or is that something you have not worked out?
I think I did try to work that out, Chief Justice. I may be wrong, but I'm subject.
Yeah, even if it's not exact, if you give us just an idea, 20 weeks, 30 weeks, 40 weeks?
40 weeks, Chief
About
Justice.
40 weeks?
Yes, Chief Justice.
Oh, okay.
Yes.
Now, let us talk about your civil and criminal, your civil court experience, starting from the district court.
Yes.
What types of cases were you doing as a district court magistrate in terms of civil matters?
Well, Chief Justice, I was dealing with evictions. And I was dealing with matters involving defamation. And yeah, and also those relating to damages. But of course, as you know, Chief Justice, the jurisdiction is limited. That's right.
When you talk about damages, what types of damages? That damages arising out of road accident fund matters, or car collisions and so on?
Car collisions, and assault Chief Justice.
Yeah.
Yes.
Okay.
Yes.
And collections, you got involved in collections or not really?
That's it. I was also involved in collections,
Yeah.
and I was also involved in maintenance matters,
Yeah.
and yeah,
Okay. Yeah. No liquidations and insolvency matters.
I only met those when I was in the High Court, Chief Justice, not in the
Oh.
District Court.
Okay. All right.
Yes.
Okay. And of course, you would have done a lot of criminal matters.
Certainly, Chief Justice.
Yes.
Certainly.
And the civil matters, did you produce a lot of written judgments?
I did.
At that stage?
I did, Chief
You
Justice.
did?
I did.
Okay. And then you went to the regional court. There, have you been doing civil and criminal matters?
I grabbed the opportunities also there, Chief Justice.
Yes.
And I wanted to balance things.
Yeah.
I did both criminal and civil.
Okay.
Yes.
Okay. And at regional court level, what types of civil matters did you get exposed to?
Those will involve, again, damages, as I've said, unlawful arrest, malicious prosecutions, and damages, as I've said, arising out of collisions on the roads, as well as collections. That's right.
Okay. And when you acted for the first time in the High Court, how did you find that experience?
Hey, Chief Justice, it was an eye-opener in the sense that I happened to be in Durban. But before I went there, the late Judge Msimang had warned me that there is a lot of work in the High Court and more so in Durban. And I found that to be the position. But because, Chief Justice, as you have said in your opening remarks, we were taught to work hard. That is our motto. And though it was difficult, the volume of work, you knew in these things, insolvency, liquidations, and motion court, opposed, unopposed, civil matters. You've got to think on your feet, and you must reduce your hours of sleep, because you must ensure that when you go to court with those files, you know what the issues are in a particular matter. You cannot take chances.
Occasion and regional court to do motion matters?
Motion matters, Chief Justice, we do not have there. It's just civil matters.
Yeah, also in the district court?
That's right, Chief Justice.
Oh,
yes.
So you were encountering motion matters for the first time in the High Court?
Exactly, Chief Justice.
Yes.
Yes.
Opposed and unopposed?
That's right, Chief Justice.
Yes. And you coped successfully?
Under Judge Msimang, I would say I coped because he did not throw me away.
Yeah.
And
yes.
That man, at any given moment in time, he would have thrown me away without any hesitation if I were not performing. Yes. Yes.
And Did you do civil trials in the High Court?
I did, Chief Justice.
Yes.
Yes.
About how many civil trials would you say you have had a chance to do in the High Court, more or less, during your acting stints? 10, 20?
I put them at 15, Chief Justice.
About 15?
About 15.
Okay.
Yes.
And the weeks when you have done motion court in the High Court, about how many weeks would that have been? Or did you not do them per week? You did them only on certain days?
We were doing them on certain days.
Or
Yes, Chief Justice.
about how many days would you say you have done motion court if you put all those days together, roughly, even if it's not exact?
Because it used to be Tuesday and Thursday
Yeah,
in a week.
yes.
I was there 35, 40 weeks.
Yeah. Uh, 80 days of motion court.
That's it, Chief Justice.
Yeah, okay,
Yes.
okay. And you have produced judgments in motion court, eh?
That's right, Chief Justice.
Yes. Now, any of your judgments that you have produced in the High Court, have any of them been reported?
Unfortunately,
Okay.
not yet.
Okay, what is your understanding of the rule of law in terms of what it is?
My understanding is that I got interested in this concept, the rule of law. And I got to know, when I traced it, that it was advocated by this English human rights lawyer, Dicey. And it's just to the fact that more so that we are a constitutional state now. Matters that involve legal disputes must be brought to institution called courts, where they'll be dealt with, in our case, in terms of the Constitution and the law. That is my understanding, Chief Justice.
And your understanding of the doctrine of separation of powers?
Chief Justice, my understanding, I would say, is simply in the sense that I understand that we've got the executive, the legislature, and the judiciary. And the purpose thereof, I take it and I should think it is that there should be no conflict between these three, more so in the performance of each one in relation to the duties assigned to each.
And the independence of the judiciary?
The independence of the judiciary, my understanding is to the fact that the judiciary, as forming part of the three that I've referred to, is that the courts are independent. And the judges should not be interfered with. There should be no interference, because the judges must not only be impartial, but they must also be seen to be impartial. That is my understanding of the independence of the judiciary.
Yes, no, thank you.
Thank
I
you,
will
Chief
now
Justice.
give the AJP the opportunity to put a few questions and Thereafter, I will give the opportunity to the MEC. They will put crisp questions to you, Mr. Phoswa,
Yes.
with a view to satisfying themselves how your appointment, if you were to be appointed, would meet the selection criteria that this commission has approved. It would follow in making recommendations of candidates to be appointed as judges. I would urge you to do your best to give them crisp answers as well.
I'll try my best. Chief
Yes,
Justice.
okay,
Thank
all
you.
right. Okay. AJP?
Thank you, CJ. Good afternoon, Mr. Phoswa.
Good afternoon, Acting Judge President.
So I just put not much questions. Are you satisfied that you are now ready for permanent appointment?
Yes, Acting Judge President, I am.
So don't you think that you still need more exposure?
No, Acting Judge President, I think I'm ready.
The GCB is of the view that you fail to grasp and apply foundational principles and concept of civil law and procedure, and in support thereof they refer to the application where you dismissed an application instead of striking it off the roll, and also to the spoliation case where you demanded that the lawfulness of the initial occupation should be established. Do you have anything to say in this regard?
Yes, I do, Acting Judge President. I'll start off with the concern that I'm failing to grasp the basic principles of civil law. That is not true. In fact, what happened in the first matter, it was said to be an urgent application. As I've said, I read the papers because I wanted to satisfy myself that indeed the matter is urgent. I could not find anything urgent. I read the papers again. I could not find anything urgent. So I then said to myself, okay, I'll be going to court the following day, tomorrow. I'll have an open mind open to persuasion. And I got in there, and we started off with the matter. My first question, I directed to the legal practitioner of the applicant. Please, could you address me on urgency in as far as this matter is concerned? Legal practitioner addressed me. Of course, in between I was asking questions. Eventually, she concluded. I then gave the opportunity to the practitioner for the respondent. Legal practitioner for the respondent addressed me. Then I came to the conclusion that there was nothing urgent in this matter. And it was a clear indication that it was nothing else other than abuse of court processes. I had to intervene. But now, I always, even when my colleagues ask me, I always stress this. Be very careful. If you find that there is lack of urgency, do not dismiss the matter. Just say the matter is struck off roll for lack of agency. I always say that even to my colleagues. I know that. Now, I've since realized that I said the matter is dismissed for lack of agency. And which is wrong, I must concede. Why is wrong? Because it closes the door to the litigant. But if I had said, as I should have said, the matter is struck off roll for lack of agency, the litigant could bring the matter at any given moment in time. But as I've researched, I think Rule 42 is applicable in this matter because that was not the intended order by the court. Then I add in that regard, I must concede. Then coming to the second one, it was, I would say for purposes of simplicity, it was an application for spoliation. What was in issue there was that the applicant was arguing that he had been despoiled. And what was in issue, the subject matter of the application was an immovable property. Now, when reading the papers, this immovable property had been executed after liquidation of the company. And it was then in the hands of the liquidators. The liquidators, because they had to realize the assets, amongst other things, for the payment of the creditors. They put up this property for sale. The first respondent, made an offer to purchase the property, and his offer was for the sum of 2.6 million rands. They agreed, and there came a day and the first respondent wanted to go and inspect the farm. He went there, he found that the farm was guarded by the security guards because the liquidators wanted to prevent further vandalization of the house because no one was there.
Chair, I suggested that, I don't know, I don't want to be rude really, but I'm not sure as to whether the acting judge president would not want to intervene or the chair intervene in terms of the fact that we have restricted ourselves to time and also find a way of directing the candidate in relation to the things that he has been asked to comment.
I think we are about to, I think the AJP is about to be done. Just keep your answers short, Mr. Phoswa.
Thank you, Chief Justice.
Yes.
To cut matters short, I found that because the requirement, undisturbed and peaceful possession, in this matter that would be occupation. First applicant and other applicants were never in any undisturbed and peaceful possession. Then I dismissed the application.
AJP, are we done?
The other thing is that you tend to make up your mind too early before hearing full arguments in a matter.
In that regard, Acting Judge President, I do not think that would be proper, because the natural rule of justice, you hear both sides.
Well, I wonder at AJP whether they give one or two examples to just respond to a general statement like that.
No, it's just a general statement. There's no specific in this one. Maybe I can withdraw it
I think move to another one that is
and go to that.
substantiated.
The LSSA has expressed concern about your health challenges. Given the rigorous demands on the judiciary, what is your view?
Acting Judge President, my response would be, I've been exposed to the work in the High Court. I know how demanding the work in the High Court can be. As a person, I first have got to be honest and sincere to myself. Ask myself this question. Should I put myself forward for appointment? Do I have the physical, the mental capacity? As I'm here, I have put myself forward because I was honest to myself in that introspection.
Yes. AJP,
Thank you, Chief Justice.
MEC,
CG, I'm covered by AGP.
thank you. I don't see any hands. Commissioner Baloyi,
Good evening, Mr. Phoswa.
Good evening, Commissioner.
Yes, Mr. Phoswa, it's really about the question that I'm going to ask. It's really just to try and find out what support you find when you go into act and what you want to propose. And I ask the question because I've looked at two of your judgments. The one is the Mr. Cool. You remember that? That's a review
Yes.
application to set aside a tender.
Yes, Commissioner.
And the next one, it's the I think MEC Finance, KZN. Then the second respondent is Brilliant. Again,
Yes,
it's
Commissioner.
about
I
a
remember
tender that has
those.
been awarded.
Yes.
Now, in both, what is common to both judgments is you are very cryptic in the way that you write. So, and you leave a lot of gaps. In Brilliant, for example, you analyze what the applicant says is the problem with the award to the party that was awarded, right? It says that they didn't meet the requirements, their application didn't contain this and that information. You say that's the analysis of the applicant.
Yes.
And then you conclude, further on, you then conclude that they were favored. The party that was awarded was favored. You don't give your own analysis of the correctness of these allegations. In fact, what is important, I thought, in this judgment is that the second respondent seems to have denied those allegations, but then you then go on to find that the award was they were favored, rather. You do that. And then there's the same trend with the case, with the MEC of Finance judgment as well, is you say an award was made of a tender, a contract was signed, and then the next thing, the awardee was demanding performance from the department, right? And then the next thing, they are suing. And it leaves the question, what is the performance that they were demanding? So the reader, internally, the judgment doesn't tell the story. It doesn't tell the reader what, in fact, were the facts on which you decided. It may well be that your conclusion is correct. It may well be. But when you read the document, it doesn't tell you what did you find to have been proven that you accepted and on the basis of which you make your judgment. My question is there support when you act as a judge? Do you find that support is provided to assist you when you write judgments? This is what you should do in your judgments. And are there any suggestions that you would make that the acting DJP should perhaps look at implementing to provide support to acting judges? Thank you.
Thank you, Commissioner. My response there would be, I know acting judge president is busy, but the spirit that I found in the Durban High Court, in Pietermaritzburg High Court, is such that you can approach any judge for assistance. And I had developed this habit of just asking the judge, please go through this judgment and see if I'm right. And I would say so to the other judge. And when they return what I've written and say, no, it's okay, then I would be content that I'm right. But I understand what you are saying, Commissioner.
Thank you. Thank you, CJ.
Thank you. I don't see any other question. Hence, commissioners attending virtually, is there anybody who has a question that they wish to put to the candidate?
No questions. Thank you, Chief.
No question. Thank you, Commissioner Breitenbach.
No questions, Chief Justice.
Thank you, Commissioner Barnard.
Nothing.
Are 2 or 3 points that you would like to emphasize, which you would like the commissioners to specially take into account when they consider your candidature, but also if you feel that important issues have been adequately addressed, that would be fine as well.
Well, Chief Justice, I wish to thank you and all the commissioners and thank the acting judge president because I'm here of him. Thank you very much.
Thank you very much. You are now excused.
Thank you, Chief Justice.
Thank you.